because the Indiana Supreme Court adopted my legal analysis.
And look, Larry, I wasn't doing lawn work today. I was actually we file tax extensions, and I was working on our taxes. But while I was doing that, I was reading it multiple times. I'm not sure why you're so excited. What's got you so giddy?
Because the Indiana Supreme Court adopted my legal analysis.
And how could you know that?
Well, easy. Read the language. If it didn't come from FYP, where could it have come from?
Perhaps they performed their own legal analysis, like they played 3D chess the same way that you do. Did you consider that?
No, actually, I never thought about that.
Okay. Well, here's the case. And this guy should not be named Gage Peters. It should be Cage Peters, because that would be a perfect supervillain name. Cage Peters. But so this is Gage Peters versus Dennis J. Quackenbush in his official capacity as Hamilton County Sheriff, and Lloyd Arnold in his official capacity as Commissioner of the Indiana Department of Corrections. The case was decided on June 19th, so that's just a couple months ago. Are you ready?
I think so.
All right. The question facing the court is whether such a person must register for the period required by the other jurisdiction, even though they committed no offense in the other jurisdiction that imposed the triggering registration requirement. The court said, we answer that question in the affirmative. Now, I'm not seeing the reason why you are so giddy here.
Well, I see the reason, because it affirms what I've been saying about being listed on a website versus actually being registered. They ultimately held because Peters is not currently required to register in another jurisdiction, that he need not currently register in Indiana as a sex or violent offender. They reversed the trial court and remanded for entry of summary judgment in Peters' favor. So that's why I'm getting.